by their parties, because there is precedence. Not only is there precedence, there's also matters that arise from how political even jurisdiction, especially for the tribunals, and that's caused a bit of a controversy, and people are wondering what's going to happen now to the lawmakers who have lost their seats on account of these, some reckless decision of the allow for National Assembly and State Assembly election matters to be tried as well, or rather to be appealed up onto the Supreme Court, because as it seems like the governor is elected on the platform of the People's Democratic Party. My guest this morning is one who understands, some of these things. He's going to be talking about that. We'll also touch on Kano State, and just to let you know, we're not probably going to talk about that because the Supreme Court has also reserved judgment for the appeals from River State and Nasarawa State. Hopefully later today they would be delivering judgment on those two. But as it is, we've seen where Abba Yusuf, retained or was returned as governor by the Supreme Court, even after the Court of Appeal had overturned and asked for his certificate of return be taken back by the INEC. This morning, my guest is Barrister Abubakar Zubair. He is a lawyer, legal practitioner, and public affairs commentator. He understands these issues and is probably going to give us a background to this and let us in on what it is, that this portends for people and the image of the judiciary, especially the Court of Appeal, that has been brought to disrepute and public ridicule by the judgment it delivered in Plateau State, especially. Governors, I just called you Governor. Barrister Elizabeth, good morning, and thank you so much for joining us.
It is a great pleasure for me. Good morning, sir.
I'm so glad that you are with us this morning. It's the first time we're talking this year on the program, and
season's greetings.
I appreciate you. Happy New Year to you. Let's get into this conversation. I love to get your reaction as a lawyer. What are your sentiments to this? To what's playing out, or the outcome of the Supreme Court's decision, and what it has done to the Court of Appeal. Do you think that this is going to make people lose confidence in the Court of Appeal, going by what the Supreme Court has said about the judgments delivered?
No, sir. The people may not lose confidence in the Court of Appeal because the Supreme Court of Nigeria has already set the correct records. There is a precedent under our judicial system. Precedent means that there are laid down rules by a higher court which lower courts must abide by. Today, as it stands, the current decision of the Supreme Court on these issues are the binding decisions in law in respect of electoral matters.
But let me cut in here. Court of Appeal jettisoning the precedents.
Yes, I will come to that, sir.
Okay.
So this precedent means that every court below the Supreme Court of Nigeria will now have to abide by the present decision. So the confidence in the Court of Appeal may wane for some time, but it will not go down completely. Because in the Court of Appeal are also justices who uphold the tenets of justice and who are honest to their calling, and whose oath to which they have sworn, they continually abide by it. There are some justices, however, and this is not only in the Court of Appeal, there are justices even in the Supreme Court who sometimes go out of the way of their oath and do certain things that are repugnant to the continued existence and harmony of our people. Now, the Court of Appeal has had that problem not today. The problem arose not even in this election year. You will recall that even election matters in the past used to terminate, especially at the governorship level, used to terminate at the Court of Appeal. What happened was, from 2007, it was observed that the Court of Appeal was making decisions that were inconsistent, even on issues that are supposed to be the same. Sometimes the various divisions of the Court of Appeal will issue conflicting judgments, which is difficult for the High Court and other lower courts to abide by. That was the reason why it was amended under the law that governorship petitions should go to the Supreme Court and should not terminate at the Court of Appeal. The classic case was that of Kabi and Sokoto State in 2007, where the Kaduna Division of the Court of Appeal, sitting as a panel, made two different decisions over the same matter. That was a disturbing scenario, and so the decision was taken and the law was amended that governorship elections, because they are very, very sensitive, should go to the Supreme Court of Nigeria. And you can see the wisdom in that, because if not for the law that made that amendment, the governor of Kano State will not still be a governor today. The governor of Plateau State will not still be a governor today. And the governor of Zamfara State will not have been a governor today. It is the amendment of that law and the wisdom of the Supreme Court that made these governors to now remain in their offices. And you can see the classic deterrent to how assembly elections ended at the Court of Appeal, especially with respect to the legislators in Plateau State. So these are some of the issues. People will not lose their confidence, but that confidence will wane on for some time. Wane means it will go down for some time. But you see, the decision of the Supreme Court on Friday has restored a lot of confidence, not only in the Supreme Court, but in the judiciary. What the Supreme Court did was based on three reasons. One, the peaceful, whether the Supreme Court should toe the line of technicality by taking technical dimensions in pronouncing judgments in these cases. The Supreme Court downplayed technicality and took the issue of substantial justice, which has always been the position of the Supreme Court in the last 20 years, that substantial justice should override technicalities, because sometimes, although technicalities are part of the law, sometimes they work injustices on parties, and such injustices cannot be corrected. Then the third issue was whether those people who were before the Supreme Court were actually the people who had the highest number of votes before the Court of Appeal terminated their victory. And then the Court of Appeal, in their place, pronounced people who had the lesser votes. The Supreme Court considered that we are in a democracy, and so the higher votes which people cast for a candidate should override every other thing in democracy, because we have had that disaster in the past. In 2007, Ebuche Amechi became the governor of Rivers State because of technicalities arising from primary elections in the PDP. He didn't campaign to be governor. In fact, he was not the gubernatorial candidate. It was Omehi who went around and campaigned and canvassed for votes. And the people of Rivers State voted for Omehia as the governor of Rivers State. But the Court of Appeal and even the Supreme Court at that time adjudged Amechi to be the governor when no single voter voted for him at that time in Rivers State. He ruled Rivers State for 4 years. At that time, you can liken that rulership to a military rule, because he was governor when no single individual voted for him because of the technicalities in our law, which the Court of Appeal at that time and even the Supreme Court taught that line. So I think the Supreme Court sought to correct this issue. Mutfang of Plateau State had the higher number of votes. More people in Plateau State voted for him. Dauda in Zamfara had more number of people that voted for him. In Kano, Abba had more people that voted for him. So these three considerations were probably the reasons why the Supreme Court adjudged substantial justice over technicality and then granted the prayers in the appeal of these three governors and the other governors that the Supreme Court delivered judgment in their cases on Friday.
Now, Barrister Elizabeth, let's talk about this, what you just mentioned, the number of votes and the number of people who voted. Now, in Plateau State, it would be that the Court of Appeal had not only just nullified the will of the people, but also subverted the will of the electorate in that state, the people who took out their time to go and vote for their preferred candidates as a majority. Now they have other people representing them at, in the parliamentary arm of government. And what does that leave? Where does that leave our democracy and the kind of politics and judiciocracy that we have in this country?
That has wrecked on the constituencies of Plateau State. It is a very sad spectre. The reason is because the Court of Appeal relied heavily on what they call lack of structure in the PDP in Plateau State. They didn't look at the issues that even the tribunal that sat initially on the issue reached a verdict over these issues. The Court of Appeal did not look at these issues critically. One, if an election matter is filed before the court, there are rules in the Electoral Act which stipulates that a petitioner can only file an election petition based on certain criteria outlined in the Electoral Act. Structure is not one of the reasons. That is one. Secondly, one of the reasons. Three, that the PDP had conflict which led to divisions, which culminated in litigations, and which litigations remain unresolved, is not one of the reasons why a petitioner can file a petition. But the Court of Appeal didn't look at those issues. We don't know why. Based on that premise, appeal held that all those who contested election, including 2 senators, members of the House of Representatives, and some members of the House of Assembly, the Court of Appeal terminated their mandate freely given to them by their people on the premise that the PDP had no structure in Plateau State. This is false because one of the issue of structure was not one of the reasons, or is not one of the reasons outlined in the Electoral Act as a basis for going to court. Secondly, if somebody disobeys a court order, are there no mechanism in law based on the inherent powers granted to the court? Are there no powers wherein a court can vent its anger of contempt on a party that disobeys it? There are mechanisms in law that if a court gives an order, the court can take steps to punish the person who has disobeyed that order. But the Court of Appeal did not look at that issue also. The Court of Appeal was more interested in terminating their mandate. We don't know the reason why the Court of Appeal did that. Then number 3, look at the number of people that voted for each of the candidates whose mandate was terminated. Now, the Court of Appeal replaced those people who were freely given the mandate by their people with people who had lesser votes in their constituencies. And these people will now parade themselves as those people who have been elected in those constituencies. I have even had the former minister, who is now a senator, saying that democracy is victorious when his votes are lesser in number than the votes of the number of the person who was terminated by the Court of Appeal. But because he is victorious, he is even praising the judiciary for upholding democracy. That is the reason why the Supreme Court made those caustic remarks about the panels of the Court of Appeal. because they didn't pay attention to these issues. They didn't look critically at the issues that were even canvassed on appeal. They didn't look at the merit of the case of these people. They didn't look at even the merit of the case of the governor. In fact, because of the low morale in Plateau State, an ex-governor even advised the governor not to go on appeal at the Supreme Court because the strength of the case of the Court of Appeal was so overwhelming. People believe that the governor of Plateau State will not succeed at the Supreme Court. But you see, when it came to the Supreme Court, they look at those issues I have outlined to you. If you know the terrain in Plateau State is one of the most volatile environments, especially now when people are fiercely divided, especially some along ethnic, some along religious, some along all sorts of mundane interpretations, and that heightened the tensions. The peaceful coexistence and harmonious living of the people of Plateau State is paramount, just as the harmonious existence of Nigeria is paramount. And this was one of the considerations of the Supreme Court. But far more than that, the Supreme Court saw that the PDP had complied with the orders of the court that said it should hold its primaries. More so, at the time that those issues arose in this case, the governor had not even indicated interest to be governor. These were things that took place a long time ago, and it was under the old Electoral Act 2010. It was not those issues that culminated into those litigations which led to the structureless statute of the PDP in Plateau State took place under the Electoral Act 2010. There's a new Electoral Act in place, and the PDP had, according to the Court of Appeal, only partly complied with the orders of those courts. But like I told you, those orders are meaningless because there are issues of contempt which the court will invoke. And most importantly, those issues of compliance with court orders are not even part of the reason why a petitioner will file a petition before an election petition tribunal in the first place. So you can see the damage which the Court of Appeal has wreaked on the people of these constituencies in Plateau State. These people will now be represented by people who they rejected at the poll. These people will be in the House of Assembly making laws for them. People that were rejected by the people at election. These people will spend 4 years making laws for the people of Plateau State any money, which in the first place, if the matter had gone to the Court of Appeal, they will not earn. Unfortunately, the law is that their matter ends at the Court of Appeal. And there is also a timeline for the time you can appeal to the Supreme Court. That time under the Electoral Act has already lapsed. The Supreme Court on its own, under the present Electoral Act, cannot listen to an appeal coming from House of Assembly, House of Representatives, and senatorial matters, because in law, these cases terminate at the Court of Appeal. Whether there can be review, that is another issue which has not yet been decided. But the important thing is that the Court of Appeal has no right under its statute and under the Constitution or any law for that matter at this time to review its own decision. The Supreme Court under the Constitution can its own decision, but this decision is not the decision of the Supreme Court. It is the decision of the Court of Appeal. And it cannot hear those appeals because it is statute banned. It has been banned by law not to listen to those appeals. So what will happen is that these legislators who have been confirmed by the Court of Appeal will remain as a disaster to those constituencies. Although they are rejected by the electorate, they will now be the ones making laws for these people in the chambers of the Plateau State House of Assembly. There lies the disaster of the decision of the Court of Appeal.
Now, I listened to Leonard Silks, Ozokeme SAN and Owonikoko SAN, have conflicting or rather diverse opinions or divergent opinions on these matter. While Michael Zuckerman SAN believes that the Apex Court should take a look at the cases, even though he knows that they may not be able to overturn the decision of the Court of Appeal or by law. He believes that maybe matters like this should be allowed to go up to the Supreme Court now, because for him this is time for him to make a U-turn on his stance on having such matters be terminated at the Court of Appeal. He also says that maybe the National Judicial Commission, the NJC, should take a look at a review or even punish these justices who were involved in this, what has been termed miscarriage of justice. But Owonikoko SAN says, look, there's no review. There wouldn't be any review. There shouldn't be any of this. Nothing like that's ever going to happen, because the PDP was also looking in that direction to say if they could get a review of the judgment of the Court of Appeal. Now, should we throw in a clause, maybe in the Constitution or the Electoral Act, that would allow for matters like this when they even if they end at the Supreme Court, when the appellants are not satisfied, for them to be able to go up to the court of the Supreme Court, as the Apex Court, as the case may be?
I believe I am more in tandem with Okoko SAN, because the truth is that this matter cannot be reviewed. The only way is to seek an outlet for the future, where the National Assembly can now amend these laws so that matters like this may end up at the Supreme Court. Because it was also again the mistake of the Court of Appeal that made these laws to be amended such that the governorship election will now go to the Supreme Court. Initially in our history, these laws used to go to the Supreme Court. Unfortunately, at a point, the lawmakers said that, and I think they were right, that the Supreme Court is bogged down by many cases, and the panel in the Supreme Court will not be able to handle most of these cases. It may interest you to know that if you file an appeal at the Supreme Court today, that appeal may not be mentioned in the next 4 years because of the number of cases of appeals coming from every nation in the country to the Supreme Court. I am also aware that the justices of the Supreme Court will now be increased, but may not be able to cater for the number of cases going to the Supreme Court. That was the wisdom why the Court of Appeal was made the final bus stop of legislative cases. But with what is happening today, I think there is need to review that law, because it shows the fallibility of the justices of the Court of Appeal, either because of their wisdom or they did it deliberately for material things. It could be any of this. Whichever the case it is, I think there is need to look at these laws again so that such mistakes in future cannot be made. This is in view of the fact that if you ponder over what is happening at the legislative level in Plateau State and how mandates were freely granted to people who were not elected, and you ponder on the implications and the fact that the people rejected them, and how they will now be coming to these constituencies to be parading as people who have the mandate of these people, you know that this disaster is unbearable. That is why the law needs to be reviewed, so that if it is possible, let these matters now go to the Supreme Court. So whatever the wisdom of the Court of Appeal may be, they can now look at it and then review it, just as they have reviewed some of these governorship mistakes that were made at the Court of Appeal. Now, as to whether our justices may be punished or not, I hold the view that in sane societies, if this judgment of the Supreme Court were pronounced in England, for example, I can assure you that most of the justices of the Court of Appeal who handle these cases will have by themselves resigned by now, because there is no honor in what has been told to their faces in respect of their conduct. But you know, Nigerians do not resign when they are holding executive, legislative, or judicial positions. The reason is because these posts go with juicy economic benefits, and so they are even more interested not in the duty they give to their country or what patriotism they infuse in these positions, but they are more interested in the material aggrandizement and what it will bring to them and their immediate family. So rule out the fact that these justices will resign. The next point is whether the National Judicial Council can be able to wield the bigger stick by punishing these people or making them retire from their positions or even lend to other people who will be appointed to other courts of records in Nigeria. My view is that the NJC cannot do that. The reason is because, not because the NJC doesn't have that power, but the NJC cannot do it because the precedent set by the NJC is that judges who even committed infractions in the past were promoted. And if you look at the list of justices from the Court of Appeal who have been recommended to the Supreme Court today, you will still see that the names of these justices who have been reprimanded by the Supreme Court, some of them have their names on those lists. In Nigeria, especially in the judicial parlance, if you commit an offense, instead of a punishment, you even get promoted. I don't know whether you can remember 4 years ago when some judges of the High Court were petitioned and various offenses, including taking of bribes, were taken against them. Do you know the recommendation given by the National Judicial Council that they will not be elevated to the next court until after 2 years? Is that a punishment? That is not a punishment, and that is why I hold the view that the National Judicial Council may not be able, in fact, it cannot take the position to punish these justices. These justices will find themselves in the Supreme Court to wreak this kind of disaster on the people of Nigeria. So I think what we should do is to clamor to the legislative houses, especially the National Assembly and other stakeholders like the Independent National Electoral Commission and other electoral NGOs to clamor for the review of these laws so that all petition cases arising from elections, even if there has to be special panels in the Supreme Court, let it be that these matters will be looked at by the Supreme Court so that we can avoid this disaster that has been wreaked on these legislators in Plateau State. Let me ask you to imagine something, sir. Assuming that one of the senators or one of the members of the House of Representatives or one of the members of the House of Assembly who have been now dismissed from his rightful position by a justice of the Court of Appeal. Assume that one of these people meet a justice who was in this panel in the market. What do you think will happen? What do you think will happen? Do they even feel happy where they are now, where the justices are distant from them? Do they feel happy with what the justices have done? More so when the Supreme Court has validated the position of the governor of Plateau State. So I think these justices have even brought more rancor to the people of Plateau State. They have even sowed more hatred, more discomfort. They have brought a disaster that will last for a very long time, but specifically for 4 years. I think the laws need to be reviewed so that we can be able to take a stance that is just, harmonious, and progressive for all the people of Nigeria, not only for the people of Plateau State.
Now, the fact that the Court of Appeal has seen a lot of ridicule coming all the way from the time of, Justice Ayo Salami, CFR, where he was in an interview where he said that he gives, election matters to justices that he trusts, and that sparked up a lot of controversy with people asking, are there justices at the Court of Appeal that cannot be trusted by the president of the Court of Appeal? We also had a similar scandal with the former president of the Court of Appeal, Justice Bokachua OFR, where her husband stood on the floor of the National Assembly, the Senate precisely, to say that he had helped, through his wife, many of his colleagues in the chambers at the time. Now we have another president of the Court of Appeal who appointed justices to sit on the panel, and this panel is brought to disrepute again. What can be done by the Court of Appeal to, redeem the image of this court?
It is not only the Court of Appeal, sir. It is the entire Nigerian judicial system that is on trial. The reason is because the press, the general media in Nigeria has refused, maybe it is complicit, to view its light, to bring that light of fact, that light of investigation, that investigative journalism. The Nigerian media has deliberately refused to beam that light on the conduct of the judiciary. That is why the judiciary is having its cake after eating it. The judiciary eats its cake and have it, and nothing is done. This thing has not started today. Even in this election year, have you forgotten the presiding judge in the Kano State Election Tribunal, who said that a senior lawyer who was before them in that tribunal had brought some politicians to her house so that they could bribe their way to get things done? Till this date, she has not been called to name that lawyer. She has not been called to name that politician. She has not left her post as a judge, and she is still serving. The National Judicial Council, I do not know, but I have not had the National Judicial Council call her to order to name that lawyer or those politicians that try to induce her. Very soon she will be in the Court of Appeal because she will be elevated. Now, look at what happened in the Plateau panel. You remember Johnson Ude. Johnson Ude made revelations that should have called the attention not only of the National Judicial Council, but the entire Nigerian citizenry, especially the executive arm of government. Johnson Ude wrote, and it was made public, when he said that one of the justices sitting on the Plateau cases was in a room. He gave the number of a room at a hotel in Ikoyi, Lagos. He gave a time, and he said that that justice was in that hotel to collect gratification on behalf of that panel. Have you had the judiciary queried him? Have you had the judiciary call Johnson Ude to expatiate on that allegation? Have you had the National Judicial Council or the President of the Court of Appeal dismantle that panel? Have you had that these justices were queried for the conduct that has been revealed to the public? Nothing has been done. You see, in the last 20 years, Nigerian judiciary has taken a nosedive because of the close affinity between higher judicial officers and politicians. Today in our judiciary, especially at the high court level, you could find more than 60% of judges whose appointments to the high court were influenced by politicians. Some of them whose appointments were influenced by the politicians are already at the Court of Appeal. In the judiciary, if you want to seek an appointment to the Court of Appeal or to the High Court, but especially to the High Court, your father has to be a judge. Your father has to be either a justice of the Court of Appeal or of the Supreme Court or a chief judge of the state. You have to be related to somebody who is in the higher echelon. If your father does not know any judge, governor, to be able to be appointed as a judge, that has been the precedent in some cases in the last 20 years. So if the judiciary has compromised to this level, that judges who will be appointed to judicial positions and who are supposed to administer justice to all citizens had been compromised to the politicians, what do you expect? Sir, in 2002, the National Judicial Council appointed 71 judges for the Federal High Court. The Nigerian Bar Association wrote to President Muhammadu Buhari. They say, please, sir, in the name of God, do not sway these judges. What the Nigerian Bar Association did at that time was to take out the names of each of the judges to be sworn in by the president, and they linked 42 of them to justices of the Court of Appeal, to justices of the Supreme Court, and to some chief judges. In fact, one of them, who was a justice of the Supreme Court, had his son appointed. Most recently, sir, let me tell you what will even shock you today. What we are having today, the Chief Justice of Nigeria has his younger brother appointed to the Court of Appeal. He has a son appointed to the Federal High Court. And when they were empaneling the audit division of the Supreme Court or of the National Judicial Council, he brought the son of his younger brother and appointed him as the auditor of the National Judicial Council. So how can you expect this institution to work for the interest of the country? It cannot. When lawyers are talking, they're treating us with withdrawal of our license as if we are not Nigerians. Am I not entitled as a lawyer, duly admitted, called to the bar after passing my bar exams? If I reach the constitutional age or the constitutional timeline to be appointed as a judge, am I not entitled, even if my father is not known, to be appointed as a judge of the High Court? Am I not entitled, if I am a judge of the High Court, to be promoted or elevated to the Court of Appeal? If you hear the story of Justice Anyebe, you will weep for this country. Justice Anyebe was a justice of the Supreme Court of Nigeria. When Justice Anyebe was called to the bar in the 1970s, I felt that Justice Anyebe should have been a professor of law in the university, because throughout the life of Justice Anyebe, he was writing cases for lawyers, for judges, for law administrators. By the grace of God, he became the chief judge of Benue State. When he became a chief judge, people who were his juniors were bypassed and they were appointed to the Court of Appeal while he was chief judge. He said this himself at his valedictory. When he was at the Court of Appeal, many favors were not granted to him. Can you imagine this? A justice of the Court of Appeal was not even regarded as somebody who is important. That even at that time at the Court of Appeal, some people were preferred over others. He said that he was surprised when he saw his name on the list of judges to be elevated at the Supreme Court. At the Supreme Court, Justice Anyebe told the Congress that many things to which he was entitled were denied him, because his father was not a judge and he did not belong to the privileged class in that Court of Appeal. The most recent answer, I'm sure you read it, are the thesis of Justice Muhammad Dattijo when you are leaving the Supreme Court. So if you look at the history of this institution, especially in the last 20 years, and you go back to the historic years when the Nigerian Supreme Court was the most golden in the whole world, golden in the sense that at that time, the Nigerian law report was read in England. The Nigerian law report was read in Scotland. The Nigerian law report was read in the USA to find the Nigerian law report. At that time, you will see Europeans quoting Justice Kayo the issue. You will see Europeans quoting Justice Obaseki. You will see Europeans quoting Justice Chukudi or Puta. You will see justices, you will see foreigners quoting Justice Muhammadu Bello. In fact, one time when Shagari was going to Germany, he was accompanied by Justice Buba Artu. When the legal community in Germany, in Hamburg, one city in Germany, when they had that Justice Buba Artu was part of that delegation, what will surprise you is that judges and lawyers across the city of Hamburg and environment were there to receive Shehu Shagari, courtesy of Justice Buba Arbu because of the preeminent position of Nigerian judges. It is not the case today. Those judges protected the integrity. Those judges protected the honor. Those judges did the right thing. Let me cite Justice Muhammad Bello for you. He had children who are lawyers, but he didn't appoint any of them as a judge. Justice Muhammad Nasir, go to Malum Fasha and find out. Justice Muhammad Nasir, most of his children, including his eldest son, who later became chairman of Malum Fashi local government, are lawyers. He was president of the Court of Appeal, but he didn't appoint any of his children to the position of a judge. At that time, they could do it without anybody questioning them or blinking their eyes. But their interest was to protect the interest of the judiciary. It is not so today. That is why you see what is happening today to the judiciary is happening to it.
Can we ever go back to the golden age of the Nigerian judiciary? We'll find out in a bit. Join the conversation now, 090-7353-0044 and 090-8766-8888. It's been an interesting conversation with Barrister El Zubair, who's sharing thoughts with us this morning on what the Nigerian judiciary has become, especially citing or looking at the decision of the Supreme Court on an appeal that had gone up from the Court of Appeal, where election matters were overturned by the Court of Appeal, and then finally the Supreme Court says it was a miscarriage of justice. Let's bring in callers now. Good morning, Elder Onoja. Good to have you join us.
Good morning. This my brother has speak all the thing when it's happening in Nigeria here. It's not only judicial. Go to Nigeria police and kill them. And go to Nigeria Army, the same thing. They appoint their own people where they can take care of their government. They appoint their brother, they appoint their sister, they appoint their son. Go to Nigeria police and see all the ranks there. And go to Nigeria Army, the same thing. The same thing politicians do. Politicians, they are the great problem to this country. But the question I went to find out from my brother there, is what of it PDP and then the cadet? Will go fight case against of those judge?
I didn't get your question, Elder Onoja. Say that again, please.
Pardon?
We didn't get your question. I didn't really get your question. What was your question again?
I say what I'm saying. Is it possible for PDP and then those cadets from the Plateau State to go and fight case in Supreme Court against the Supreme Court?
No.
And then Minister of Justice.
Okay.
For appointing those corrupt judges and federal government, is it possible to go and fight case against the Supreme Court?
All right. Thank you very much.
That case.
I think he already answered that, saying no, there wouldn't be any review of the court decision. So that's there to be in the next 4 years. Maybe they can go back and contest again. Hello. Good morning. Hello. Good morning. Okay, sounds like that one dropped and left us. 090-7353-0044 and 090-876-68888. We're wrapping up the conversation in a bit. Let's get your thoughts in. Hello, good morning.
Yeah, good morning, my friend.
Good morning. Is this Hundu?
My friend, this is
Paul.
I don't know how to. Yes.
Paul, good morning.
This is good morning, my prince. Barrister good morning. You have known so much. You have got so much revelation this morning. All these things that you are saying is happening to my in-law and lawyers took the exams for to become a judge in this country. He was pushed out. The guy left this country. He moved his family. He's now in the UK. You see, the injustice in this country, you see it so glaring and nothing can be done about it. How do we justify the saying that the judiciary is the last one of the common man? How can we justify that statement now? Secondly, my second question to you is this. Can you just enlighten me? Can these cases, this plateau case now of Court of Appeal, can it be used to be cited in another case in case it happens in the future? Can it be used as a precedent to be cited in a case in case it comes up in the future?
All right, Paul. We'll get you on that one. He's going to answer that shortly. Let's bring in this one quickly. Let's hear you. Hello, good morning. I always beg you when you're calling in, put down the volume of your radio. You don't want to bust my eardrums, please. You don't want to have my ears ruptured. Do well to turn down the volume of your radio so that we can have a clear conversation. It's not also good for quality broadcast. We're about premium and quality here at Eagles 102.3. So please, when you're calling before it's picked up, turn down the volume of your radio to the bearer so that we can hear you. Hello.
Hello, good morning, my priest.
Good morning, Hundu Tekinbe.
And good morning, your guest.
Thank you, sir.
I think I really want to appreciate your guest this morning for doing justice to this topic today. My name is Hundu. Yes, all the way from today this morning. I think the question I want to ask your guest the judiciary is supposed to be the last man. But what we have seen in the last few years, sometimes one tends to be confused. The question I want to ask this morning, there was a case in Bayelsa where the governor was elected and he was having to be sworn in. And is this correct? They're not supposed to have removed the deputy governor and allowed the governor.
Apologies, seems like the network did you in. Dr. Barrister Isabel, where would you want to begin? Would you want to begin with Hundu, who's asking if the governor is removed? Well, the governor is removed when the infraction or the alleged forgery or the forgery is done by the deputy. Why do you have to remove both people? I think that situation happened in Bayelsa State as well.
Yes, that is at that time the Supreme Court, the Court of Appeal and the Supreme Court based their judgments on the fact that the governor and the deputy governor were enjoying a joint ticket. So they applied the technicality at that time, not the substantial justice. That was why that disaster, just like the one in Plateau State, happened in Bayelsa. Because the common sense will have dictated that what has the governor done? The governor didn't do anything. The governor was perfect in respect of his qualification. The people of Bayelsa State voted for the governor. So what was his fault? If substantial justice were applied and not technicality at that time, Leon will have ruled Bayelsa State for the 4 years that Diri had ruled. But the Supreme Court and the Court of Appeal at that time applied the technicality aspect of that case. And that is what the Supreme Court has corrected in the recent cases that have been pronounced on Friday. That substantial justice should override technicality. Because it is only substantial justice that can bring harmony, unity, peace to the country. Without justice, there is no way, no matter how technical you interpret the law, there is no way that there can be peace in the country. If not that Nigerians are peaceful, you can imagine what will have happened in Bayelsa. If Nigerians were not peaceful, you could have imagined what will have happened in Rivers, where I cited, where Emechi did not get one vote, but he ruled that state for 4 years. You could imagine what will have happened in Zamfara, where the Mutawallang Amaradu was made the governor when he had less than 300 votes over his colleague who won the election. You could imagine what will be happening in Plateau State if not for the peaceful coexistence of Nigerians. I think I agree that substantial justice should override technicality. It is technicality that caught best injustice in Bayelsa State.
All right. Paul and Elder Noja were asking if this matter could be reviewed. The Plateau State matter can ever be reviewed, and if it can serve as precedence in other matters. I think that you answered that question earlier because we have to wrap up.
Yes, sir. Legally, my view is that the law does not permit either the Supreme Court or the Court of Appeal to look at that case again. What we need to do is to clamor for the amendment of the law so that in future, those cases, even if it means getting a special panel, can listen to appeals arising from legislative matters across the country. Right. So that if we have this kind of scenario, we expect the Supreme Court to correct it as they did in the case of the governors.
Barrister Abubakar Zubair El-Zubair, always a fantastic conversation with you every time you're on the program. Thank you so much for talking with us this morning. Really appreciate it.
It is a great pleasure that you give me the opportunity to speak with Nigerians. This is our mind. We are hustlers, we are wretched, we are poor, and we speak our minds for the majority and overwhelming people of Nigeria. Thank you very much.
Thank you again, Barrister El-Zubair. And this is where we'll leave the conversation today. To everyone who's been a part of it, thank you for sharing your thoughts and, totally being there listening